Once a bill makes it onto the calendar, it will go up for debate. When debating a bill, members of Congress can pick apart the bill's wording, its consequences, and its requirements. It can also be amended. It is common for laws to be amended or changed even after they become official laws. Remember that these changes are called amendments. In the case of our bill, members of the House might debate whether it is possible to lower our emissions by the percentage that we proposed, or whether it might take longer to achieve this than the representative originally stated. Members might amend our initial bill to state that the country will lower emissions in 10 years instead of 5. After the debate period is over, the bill amended or not is presented for a vote. Members of the House vote on the bill. They may say yea, nay, or present. A vote of present means that representatives wanted known they were in session that day but did not give an opinion on the legislation one way or another. A bill needs a majority of representatives to vote yea for it to be passed on to the next step. Then, the bill travels on to the Senate, which repeats the steps of committee, debate, amendment, and voting. In the Senate, 51 senators need to approve the bill for it to pass. If both chambers approve the bill, it is enrolled, meaning it is due for consideration by the U.S. President. Article I of the Constitution gives the President the power to sign the bill into law or to veto it. A veto means the President has rejected the bill. The President has 10 days to veto a bill. If he doesn't take any action and Congress is in session, the bill becomes a law. The President can also enact a pocket veto, in which he refuses to sign any bills into law during the 10 days before Congress adjourns. This prevents those pending bills from becoming laws. To date, there have been over 2,500 vetoes, almost 1,100 were pocket vetoes. Franklin D. Roosevelt vetoed 635 pieces of legislation during his terms as president. In more recent years, President Bush and President Obama each vetoed 12 bills. So, what happens if a bill is vetoed? The president's word is not always final. It can return to Congress for reconsideration. If they so choose, they can override a presidential veto by a 2/3 majority vote. Of the total number of bills vetoed in U.S. history, only around 110 have been overridden by Congress. This makes the process of a bill becoming a law even more difficult. Party pressures or other factors can influence a president to veto a bill and keep a bill from receiving the 2/3 majority vote to override the veto, even if the bill passed through Congress the first time. What percentage of bills do you think get made into laws each year? If you guessed less than 1%, you would be correct. In other words, for every 100 bills proposed in Congress, fewer than one actually become a law. The rest may be proposed again at a later date with changes, or they may simply die in Congress. State laws are formed in much the same manner. State congressmen and women will propose a bill, and it moves up through the ranks until it reaches the governor. The governor then has the power of vetoing or accepting the bill. Things are a bit simpler on the local level. Many local governments have only one governing body, besides the court systems, that devises ordinances. Ordinances are rules that govern local areas. Each town has its own ordinances, which are enforced by the local police. Because society is constantly changing, laws sometimes must change as well. The U.S. Constitution contains 27 amendments. The first 10 were added before the Constitution was ratified in 1791. The most recent amendment was added in 1992 and dealt with the compensation of congressmen and women. Some of the changes that have been made include giving women and racial minorities the right to vote and abolishing slavery in the United States. Ultimately, the U.S. court system, or the judicial branch, is responsible for determining whether a law is constitutional or not. The court system hears debate on whether certain laws violate the fundamental rights outlined by the U.S. Constitution. When the courts make a decision, this decision becomes part of case law. Case laws relate to the idea of stare decisis, or the practice of making decisions based on previous cases. The case involved then becomes part of any future laws. The case of the Vernonia School District's drug testing at the beginning of the unit is an example of how laws develop through court cases. Once a law is created, it cannot be erased. However, it can be repealed or revoked. For example, a case on a rights violation will first go to a district court where a decision will be made. Then it can move to the U.S. Court of Appeals. Finally, the Supreme Court can decide whether to hear arguments on the case. The Supreme Court is the highest court in the United States and their decision is final. They can turn a case down. refusing to hear it, or agree to hear arguments and vote on whether the law is constitutional or not. If the Supreme Court turns down a case, the plaintiff must accept the ruling of the lower court. If the court decides that the actions of the defendants did in fact violate someone's constitutional rights, the actions will be declared unconstitutional, and the law will no longer apply. Courts make decisions and seek to further interpret and apply the laws outlined in the state and federal legal codes. They then seek to determine if these codes violate the ultimate voice in our legal system, that of the U.S. Constitution. When laws conflict. Supremacy. Nothing in the United States legal system is more powerful than the ideal found outlined in Article 6, Paragraph 2 of the United States Constitution. It reads, "This Constitution, and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding." With all the thereofs and shall be mades, it is a long and often confusing sentence, but its impact is far-reaching. This clause, referred to as the Supremacy Clause, states that the Constitution of the United States is the highest power in the land. Nothing, either on the state or the federal level, can override anything outlined in the U.S. Constitution. This is why a federal court, Supreme Court, can label a law as unconstitutional, rendering it null and void. The Supreme Court is the only court with this power. Local and state courts are not granted this privilege. The Supreme Court is the highest court in the land, and when it comes to the constitutionality of a law, their word is final. For example, if our emissions bill became a law, the Supreme Court might decide to hear a case arguing that the emissions law violated an individual's constitutional rights. If the Supreme Court decided that it did do this, our bill, now a law, would be overturned. It would no longer be a law. When applying the Supremacy Clause to court cases such as Tinker and Earls, it's clear that the Supreme Court was holding the amendments, 1st, 4th, and 14th as written below, as absolute law. The actions of the parties involved were judged against the standards outlined in the amendments. The Constitution will always hold the final say in every court case this country will ever see. For example, the First Amendment states that all citizens have the right to free speech. The Supreme Court decided that wearing the black armbands was a form of free speech that was constitutional and that needed to be protected for not only the students but all citizens. The decisions in the cases mentioned in this unit were derived from the words of the First Amendment, Fourth Amendment, and Section 1 of the 14th Amendment of the U.S. Constitution. The power of the citizen. No one has the right to speak up about a law as much as the people whom it affects. In fact, many people would argue that we all have a responsibility to take an active part in speaking up about laws and potential laws. Citizens of the United States can influence their legislatures in a number of ways. First, they can write to their representative in Congress, at the state or federal level. They can also, after going through the proper channels, address Congress directly. Finally, if they feel their constitutional rights were violated in any way, they can instigate a lawsuit. People can also influence Congress by voting in local, state, and national elections. Those who vote control who enters various political offices and can affect those politicians' votes on issues and bills before Congress. The government of this country is designed to reflect the needs and wishes of the people it governs. Without people voting and voicing their opinions, the government would have no notion of what the people are feeling or needing. Citizens have a responsibility, both to themselves and to future generations, to vote. If they do not vote, they are not getting their say. The United States is a country founded on what its people say.